Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Well, we have a very important topic here today. Well, all of the topics are important, but this one really determines whether the plaintiff's complaint is going to survive the defendant's motion to dismiss. We're going to discuss when the magistrate judge recommends dismissing the plaintiff's complaint and how to object. And to demonstrate this process, I'm actually going to go over a sample objection of a real case. So let's get started. So let's talk about the magistrate's findings and recommendations and what that process really involves. After the defendant files their motion to dismiss and the plaintiff responds, the district court judge submits it to the magistrate court judge for review. The magistrate judge reports his or her findings and recommendations to the district court judge. And you can find this at Federal Rules of Civil Procedure 72B1. After the plaintiff receives the magistrate judge's report and recommendations, the plaintiff will have 14 days to object in writing. You can find this in Federal Rules of Civil Procedure 72B2. So let's talk about some reasons why a plaintiff would file objections. For one, it's the plaintiff's right, and that right is addressed in Federal Rules of Civil Procedure 72B2. Another reason is the magistrate's findings are not the last word. The judge makes the final decision, and you can find that in Federal Rules of Civil Procedure 72B3. Now, if you've been watching my videos, you know I am big on facts. It is the facts that help make the plaintiff's case. So that's another reason why a plaintiff would object. When the facts are on the side of the plaintiff. Federal Rules of Civil Procedure 8A2 is clear that the plaintiff must present short and plain statements. That is, the statements must present facts that are plausible. And if you reviewed my video a couple of weeks ago, I talked about plausibility. Facts. State the facts. The next reason is that the law is on the side of the plaintiff. Now, the plaintiff must be able to identify the law they're relying on in order to tell the court what their demand is. Federal Rules Civil Procedure 8A3 requires the plaintiff to state the demand for relief sought. So in some way, the plaintiff needs to make that known in the complaint. Some time ago, I uploaded a video on how the complaint is constructed and how it includes the law that the plaintiff relies on in making their case. The law is on the side of the plaintiff. Another reason why the plaintiff would object is that they can bring the complaint into compliance. What am I saying? Let's say, for example, that the plaintiff misstated a law or cited the wrong law, and there is an actual law that supports the plaintiff's case. Well, the plaintiff could move to amend the complaint to bring it into compliance with the law. Federal Rules of Civil Procedure 15 covers amending complaints. Another reason why a plaintiff would object. By filing the objections, the record is preserved for appeal. And here's my motto. If a party believes that their case has plausibility, be prepared to take it to the United States Supreme Court. If the facts are there, if the law is there, be prepared to go all the way. Federal Rules of Appellate Procedure 3. At the beginning of the video, I told you I would go over a real objection and show you how it's done. Well, that's what we have here. We're going to look at the structure of the objection that the plaintiff could actually use in constructing their objections. This lawsuit has been filed by Electronic Privacy Information Center against Federal Bureau of Investigation. So let's go through the structure and demonstrate how it's done. So the information you see here highlighted in yellow, the plaintiff could actually use this language to begin their objections because it is real language, which can be found in Federal Rule 72. Now, of course, the information not highlighted here, the plaintiff would have to tailor it to their case, and also they would have to include the dates that are applicable to their case. Now notice that this plaintiff, Epic, objects to 3 of the magistrate's recommendations. And I put little notes in this presentation ahead of time so that I can discuss each of them. So here plaintiff identifies the recommendations that they object to. Objection 1, Objection 2, and Objection 3. My note here says that Epic states all 3 recommendations were based on errors of fact and are contrary to law. Now what Epic must do and will do is present the facts and the law supporting their contention here. The next thing Epic does here is address the standard or state the standard of review to show any deviation from the standard by the judge. Look at my note here. State the law and the local rules in the jurisdiction the lawsuit is filed in. And that's what Epic did here. They state the local rule 72.3c provides that a district judge shall make a de novo determination of those portions of a magistrate judge's findings and recommendations to which objection is made as provided in paragraph B, and so on and so forth. Now, of course, the plaintiff wants to cite the local rules in the jurisdiction in which their lawsuit is filed. Now, here is the argument. Now, let me say this. In making these objections against the magistrate judge, in no way disrespects the magistrate court judge, nor does it disrespect the district court judge. The plaintiff is simply making his or her case. They have that right to do that. And they should use every tool available to them to make their case. We'll look at each of those 3 objections individually. Epic is entitled to full attorney fees for the time spent drafting and filing the complaint, reviewing documents, and litigating the fees issue. Now remember, some time ago I did a video on mirroring the defendant's motion to dismiss, in this case, the magistrate judge's findings and recommendations. So let's look at my little note here. This is Epic's first objection. And it sounds like the magistrate judge recommended that the district court reduce fees plaintiff asked for in their complaint. Because we don't have report and recommendations. We can tell from the plaintiff's subheading here that the magistrate judge recommended that the district court reduce fees plaintiff asked for in their complaint. Because plaintiff's subheading says the magistrate's recommendation regarding the fee reduction for the complaint is logically impossible. Epic spent a reasonable amount of time drafting the complaint. That's what we mean by mirroring. Make it easy on yourself, plaintiff, and just mirror what the defendant wrote, in this case, what the magistrate court wrote, to refute what they wrote. Here is an example of Epic refuting what the magistrate judge wrote. First, let's look at my notes. Epic's provided facts that support their objection and shows the court where the evidence can be found in the record. Epic's attorney spent 18.4 hours researching, drafting, editing, and finalizing the complaint and filing associated documents. They're refuting, right? They're mirroring. They refuted what the magistrate judge wrote. And they told the judge where they can find the evidence to support their argument. And that would be the underlined information here. Let's move on. Let's see what my notes say here. Plaintiffs continue to argue the first objection and cites case law. And that's what we have here. So Epic is arguing neither the FBI nor the magistrate can cite a single case that supports the conclusion that this is an unreasonable amount to bill for preparing and filing a complaint. And courts in this circuit have previously rejected such minute objections to fees for work done of a specific element of a FOIA. And what they've done is cited case law. And you see the importance of citing case law and providing facts that can be located in the record to support the plaintiff's objections. Do you see that? All right, let's go on. This is Epic's second objection, and let's see what my note says. Objection 2, see how plaintiff continues to mirror the judge's findings. Apparently, the judge found plaintiff's attorney spent too much time on reviewing documents. Epic wrote, Epic is entitled to bill for time spent reviewing documents as a necessary part of this litigation. Again, I call this mirroring. Let's see what the note says. Again, plaintiff supports their argument with evidence and cites where the evidence can be found in the record. Epic stated here, Mr. Butler spent a total of 11.1 hours on intake and review of the 4,377 pages of documents released prior to the August 2013 Joint Status Report. Epic tells the court what evidence supports their argument and where that evidence can be found. The motion bill at 8 through 12 Joint Status Report, ECF is electronic record number 23 at paragraph 8. See what my note says. Plaintiff objects again by citing a case that supports their argument. Plaintiff says, courts in this circuit have held that plaintiffs may be compensated for time spent reviewing documents produced during the course of the litigation, and they cite case law here. The underlying information is case law. Let's move on. Objection 3. Epic is entitled to recover fees on fees. Apparently, the judge found plaintiff's request for fees is not compensable in a FOIA case, a Freedom of Information Act case. Plaintiff argues they are compensable, and plaintiff cites case law. Plaintiff states courts in this circuit have repeatedly held that hours reasonably devoted to a request for fees are compensable in a FOIA matter, and they cite case law. Plaintiff again presents evidence to support their argument. The magistrate also recommended deferring on a decision with respect to fees on fees until the trial court's final determination of fees and accounting for the hours spent in litigating fees. You see here where, again, and tells the court where it can be found. Report at 13 through 14. Finally, let's see with this last note. The plaintiff continues its objection regarding deferring fees on fees, and they cite law supporting their position. Epix wrote, second, the magistrate's recommendation that Epic's fees on fees should be deferred has no basis in fact or law. Now you see what they're arguing here is that the court erred in the law and they erred in facts. And Epix cite cases to support their argument. Epix objects to the error of facts and the recommendation that are contrary to law in the magistrate's report. That's really important. So they're outlining or highlighting what they present as the magistrate judge's errors of the fact and the law. Sign the objection and don't forget the certificate of service. I trust this has been helpful to you. And as always, I'm Advocate Lucinda B.M.